Great. I think the recording has started and we are streaming live. So good evening, everybody. Thank you very much for joining the KelpHR and ILA discussion. Before getting started on our discussion, I would want to invite Madhura.
Yes, Smita. Hi. Hello, everyone. Good evening. Sorry, I have a little bad throat. I hope I'm clear and audible. So it's an absolute privilege for us at ILA to have been working with Smita and her expert team of professionals around this series. It's a pan-India by lawyers, for lawyers, not-for-profit organization, and we have been establishing and energizing chapters in all the big cities of the country. We have a current presence in about 75 cities, and the chapters are independent in their functioning and have the liberty to orchestrate their activities. These chapters, they host numerous meetings for their members, help their community by fostering pro bono assistance, create mentor-mentee relationships, provide accessible support to younger lawyers, create a referral network, and basically they have a lot of fun while they do all these activities. So we invite all of you here to participate in the activities that we undertake in your own cities, and we'll send out details to you on email. I'll hand it back to Smita. Thank you.
Thank you, Madhura. Take care of yourself and get well soon. A quick introduction about KelpHR. We started in the year 2013. It was exactly the same year when the country got the law. My name is Smita Kapoor. I am the co-founder at KelpHR. And creating safe, happy, and inclusive workplaces is our motto. That is what we live by and practice. We have an extremely diverse team, which is based pan-India, and it is very interesting. And I leave that discussion for another day, how diverse we are. The topic for today's discussion is cost of non-compliance. A lot of people would say that we really know it. Why should we be discussing? But to begin with, do we know what is compliance? So that is the discussion we'll start with. I have with me two eminent panel members, Sumit Bhatia and Jyoti Grover. About Jyoti Grover, she's the chairperson of LCC for Gurugram district. With effect from January 23rd, 2022, she's appointed as chairperson of the LCC. She's held a position as a member of local committee from January 2019 until December 2021. September 2021, she had begun an activity in actively engage with individuals and organizations in creating readiness and confidence to deal with real life personal and work challenges through career conversations. She has set up a not-for-profit entity called School for Life, SOL, in 2014. So SOL is an initiative targeted towards women and child protection and empowerment as an IC and child protection committees in various organizations and schools. She has conducted several inquiries and workshops to skill members in effectively performing their role as a prevention and redressal body under Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, POSH and Juvenile Justice Act. In April 2020, SOL set up an afternoon school Amber for less privileged. So that's, I'm sure I have another 2 pages written about her, but I know maybe we'll have a separate conversation about what exciting work she does. With me, I also have Sumit Bhatia. He is a designated partner and head of human resources at SE2 India. SE2 India is an organization, again, based out of Gurugram. He has over 23 years of experience in IT, ITES industries, spanning in multiple areas. He's currently designated partner and head of human resources. As a global leader, he focuses on shaping organization culture, maximizing potential of employees to drive growth, and building a workplace to support organization transformation. He has expertise in leading people for large multinational companies and a high growth startup. He has successfully built an organization, HR functions and teams from grounds up, and bolstering retention, engagement, and performances. So welcome, the two power pack team that we have from north of India. Jyoti, Sumit, welcome on board.
Thank you.
So as I told you that to understand what is non-compliance or what is the cost of non-compliance, we should understand what is compliance. Now, Smita being Smita, I would want to draw a parallel, right? We don't live in jungle world. We live in a society which has rules and regulations. So simple rule for the day or city is that when you drive, there is a signal, okay? A signal which has lights, red, amber, and green. Green means you can go ahead, red means you have to stop, and amber means you get ready. And I don't have to explain that. I'm sure even kids would know it. But what happens if you break the signal? If you take your car off in signal? So compliance is exactly that. What is minimal required for any organization or setup to be doing? Okay, so what are those minimal action that an organization needs to take from PoSH perspective is today's discussion. All right, so under PoSH Act, what are those? So annual report sent by IC to employer and district office containing details of the sexual harassment proceedings. So this happens on annual basis, 1st January to 31st December of that particular year. Annual report gets sent. This is covered under section 21. Okay. And whose responsibility it is? It is IC and employer's responsibility to ensure this is done. Constitution of an internal complaints committee for every organization which has 10 or more employees is covered under section 4. And whose responsibility? Of course, the employer's responsibility. Display of posters, notices in prominent places within the organization, informing employees that about the zero tolerance towards sexual harassment and telling them about the sexual harassment is a criminal offense. Again, it is a requirement. It has to be done on immediate basis. It is employer's responsibility to ensure this is done. Of course, IC plays a big role here. This is covered under section 19B. Capacity building workshop for members of IC covered under rule 13D. This has to be done on periodic basis. Is there a mention that it has to be done yearly, monthly, quarterly? No, nothing. But as a good practice in KelpHR, what we encourage organizations that at least do it once a year. And we also support organizations to conduct something which is called quarterly review meetings. In that, it becomes the IC members' responsibility or IC external members' responsibility to come up with one topic and upskill the IC members to understand what's happening in the space. Is there any news, any case law that they need to know, any fresh cases that external member would have handled? So this only helps them upskill themselves, upskill the IC members on periodic basis. Okay. The next important compliance is formulate and publish a PoSH policy under Rule 13A. Of course, immediately any organization, any and every organization should be having it, and whose responsibility it is? It is employer's responsibility. Following principle. Now, this is during the proceedings, right? Following principle of natural justice, of course, it has to be done as per the compliance, and that could be challenged if not followed. The next important one is confidentiality, creating particulars of the complaint. The entire particulars of the complaint should be confidential as per section 16 during and after the inquiry, and all stakeholders involved in it are responsible for the same. Creating an inquiry report and to be prepared in thorough, reasoned, and clear manner is also a part of compliance as per section 13. It has to be done within specified timelines, and it is internal committee's responsibility. Supporting the victim to file an FIR at the police station and supporting them further is, as again, the responsibility of employer and internal committee covered under section 19G and H. This is anytime such situation arises. So these are important for us to understand from the perspective that what is compliance? What do we mean when we say compliance at PoSH? We've tried to summarize it, and I would want to bring Jyoti to share any input to start with. If you think we've been able to summarize this well, if you have any thought process around this, Jyoti.
Okay, so I think you've actually pretty much captured most of it. I think the important piece here is, and we're only talking about the compliance, we're not talking about the penalties for non-compliance, I'm assuming, right? So the only important piece here is that when it comes to the compliance requirements, there are specific requirements which specific states and districts have laid out. And I know it's difficult to put everything, on the screen. Like, for example, I'm aware that Telangana and Maharashtra, for instance, want the registration of ICs. One wants it on some she-box, one wants it in some other way. The Gurgaon district wants the local committee details to be displayed. And that then becomes a violation if that doesn't happen. And we know now that there are other states like Kerala, for example, there was they didn't even have local committees. So now, as and when the local committees are being set out, I'm sure different districts will also come up with their own specific, additional compliances basis the role which has been broadly laid out for the district officer under the Act. So I think that's
very interesting. Actually, you're right. Maharashtra has something specific. I think even Noida wants the registration, is what I realized. Noida and Telangana, which is such an important aspect that we should not forget. And I remember one of my clients at Gurugram had called saying that there was a visit from authorities to their office, and this was during the time of lockdown. And the posters put up, they were not happy with it because the posters were in English language and they were requesting that it should be in Hindi too. So, so the client was saying, but there's no mention of it in the law. So we were like, if it is a requirement, let's do it. I mean, how difficult it is to have. And it's logical, right? Not everybody would understand English who comes to your workplace. So these are small things, and I think it's a good idea to create a laundry list of such things, and like a library. So I'll take it on me to do that too. And thank you very much for that. Okay, so asking you this question, that according to you, at what point do you think the compliance get triggered? Is it that organizations who are less than 10 do not have to do anything regarding compliances? Is it triggered only after the number 10 employee gets achieved? Because I get a lot of these requests saying we are at 9, we are going to hire 10, we need PoSH compliance, right? So what is your view on this? And do LCC details have to be displayed if the employees are less than 10 employees? I mean, for example, in my house, I have a couple of people who work for me. So should I be taking them through a training program? I just want to hear from an LCC chairperson. What does she?
No, that's interesting, because I think these are questions which also have come up to us as well. So I'm going to give you the legal bit, and then I'll share with you practically what's been happening. Legally, the compliance of constituting the IC comes only when you're 10, employees. However, the Act is applicable from day one. I mean, you may have 1 employee or 2 employees or 3 employees. The only difference is that if you have less than 10, you don't need to have an IC, but you still need to have, some displays and some broad policy which talks about, the protection of women. Obviously, this policy has to be in line. The Act does not penalize in case you don't have a policy. Okay, so ultimately it boils down to, practicalities, where you say that if you are less than 10, you must, as part of your induction, talk about the fact that, you are compliant or you're sensitive about, women protection. And also, if not have displays or anything, at least have sessions. And I'm talking about organizations, and specifically I'm talking about startups, because there I find startups and some of these retail shops, where this happens. So practically, let's say if it's a mall or if it's like a cohort of shops, then people actually do combined sessions, taking them through what the act or what the legislation has to say, and then sharing details of the local committee. Now, in malls, for example, local committee details, it's a good idea to put up, and there you talk to the mall management and so on. But where domestic staff is concerned, I have honestly not come across a case in the local committee so far where a domestic staff has come in. Most of them have actually, I'm aware because we are in touch with police stations as well, that they actually prefer filing an FIR. So there, right now, as we speak, there is a proposal, at least in the local committee of Gurgaon, where we are looking to touch base with the RWAs and also with local communities and local NGOs to run programs with unorganized labor and with domestic staff, just taking them through. Having said that, I will also admit it's not something very successfully done, because honestly, at that level, they're not so bothered about protection. They are more worried about financial returns. So how we are doing this is actually combining it with some financial inclusion, and then towards the end talking them, that if you're going through a violation, then this is what you could do. Yeah.
Thank you very much for that. And I would want to bring in Sumit. Sumit, I can't see him. Yeah, there he is. Okay, Sumit, thank you for coming. So hearing from Jyoti, okay, I have a question. As an employer, you are an employer, right, of your organization. You're the HR head. You are owner of the entire policy, right? So I want to understand that who is liable for non-compliance in the law? Is it employer? Is it IC? So what, according to you, where does the responsibility finally rest?
Okay, definitely the employer. So say IC is formed as a part of the employment or the organization, right? So the employer is definitely liable. And I, from a legal perspective, as Jyoti was also saying, that, 10 is a number beyond which you need to be legally compliant on some of those aspects. But if you're 8 or 9 and you have female associates working with you, would you not want to look at their safety security, right? So it's not just looking at law, but also ensuring safety security beyond being asked by law to do it. So it's definitely an organization and an employer responsibility towards it. IC is formed by employers, so that's one of the responsibility they have to take to form that committee.
Okay, so Sumit, just a further question to that is, there are times when there is a mix-up between what is IC's role and what is employer's role, right? And in such situation, okay, if IC finds that there are some things which I've been repeatedly asking employer to do it and it's not happening, or employer feels that there are some things that IC should be pulling up, okay? So how do you think, these are very softer aspects, never written down in the law, but if there is any non-compliance happening because of this TT, the ball being passed from one court to other. Yeah. So how do you think, you being the HR head, would you advise anybody in that space to manage this, handle this?
So there are two aspects to it. One, the IC also has an external member as a part of the IC. It's not just formed by the internal organization team. So one of the responsibility also is of the external member to keep the employer also in check and the IC also in check, so that there is not a conflict of interest, so to say, or they are collaborating with each other and not conflicting with each other. So that's one aspect. And then if that still doesn't occur, then we need to look at the LCC, for example, which is even outside of it, and take their help around it. So those are kind of things that we'll have to look at. And there could be cases that we can look at where the employer as an IC would have said and recommended few things, and employer would have said, no, I don't agree with you. either in a right way or a wrong way. But then there could be other ways to manage that conflict. One, of course, like I said, external committee members plus going to LCC then outside of this and saying, can you help resolve it for us?
Right, right. So that's an important aspect. What you're driving to say is that we can look at external member to get in those expertise and guide us, be like somebody whom we look up to as an employer, as an IC. So it is very, very important that we invest right and bring in the right member who can steer this through. So I have a question on external members' role, Jyoti, and that is what I'm going to bring it to you because you are an NCC chairperson. Now, external members, can they flag off, and to whom can they flag off any non-compliance if they have seen that they have done enough to tell IC that there's some non-compliance happening, and they have told employer that there's non-compliance happening. They've tried the softer aspect. They've tried giving the reprimands or send them notice or stern warnings, but it is not happening what is required for a particular proceedings to continue. So where can external member highlight it, or should they be highlighting, or what is their role basically, or should they just keep quiet and move on? So what do you recommend here?
So let me just break this up because, there are just too many perspectives. One is where the external member is finding the IC violating principles, of natural justice, for example. And the external member is in that sense, playing the role of somebody who is actually protecting and reminding the IC about, the process. And the IC is not willing to go ahead because maybe they're coming under pressure from the employer and so on. So here, under the Act, unfortunately, there is nothing, there's no leeway given to the external member to flag it. But practically, as we've discussed earlier also, the external member could, go to the district officer. Sometimes, in the LC also, these people come in, but the LC's jurisdiction is limited. The LC can't go and, for example, reprimand the IC of that company. And to be honest, we tried to do that once or twice in the last couple of years, but actually it has boomeranged. So the best way to do this is to actually, even if let's say it were to come to the LC, then the LC should make a recommendation to the district officer, because under the Act, any action to be taken by the, on the employer or via the employer to the IC has to be by the district officer. So the recommendation, so if the external member were to come to sort of flag this to the district officer, that would be best. If not, if let's say it was to come to the local committee, then the local committee on the behest of the external member would recommend to the district officer, because for example, there is a provision of having nodal officers. Now the nodal officers are appointed by the district officer. So the local committee doesn't really have a jurisdiction of the nodal officer. So for a particular, let's say, area, the nodal officer can be sent by the district officer, to make sure that the IC, gets a reminder, or to make sure that the employer is following whatever the provisions of the law are. Sometimes, like in the current situation, in the nodal officers that we have are actually government, district magistrates. So it just makes it a lot more, I would say, it really puts the employers on guard because they can't take a chance. In the past, we've had nodal officers who were honestly just biding their time, so nobody was paying attention to them. So that's one thing that the external member can do. The other, of course, as we discussed, I mean, they can always go to the National Commission of Women or, other authorities like like in every district, there is also a program officer who is the representative for women and child development at the district level. So they can also go there if they don't feel very comfortable. Indirectly meeting with the WCD, like in Gurgaon district, we have a very strong lady. So she picks up those cases. So even if the external member were not to come to the LC or to the district officer, the WCD person, can be written to. So that can be done. Now, that is where the violation is by the IC. If the violation is by the complainant or by the respondent, there the recommendation would always be to, take the matter to the employer and to, and I think a lot of companies don't do that, but they need to preempt that there will be a violation. For example, violation on confidentiality. So in such cases, the external member can advise the presiding officer to make sure that the code of conduct is aptly, provided for. You remember the Uber case? So in 2017, I mean, what we remember is this guy, the founder, he quit. But actually, there was a series of incidences that happened. And there is one that I remember. So this guy, again, I don't want to breach confidentiality, but one of the guys who was an ex-Google employee, he had failed, to disclose when he joined Uber that he had been implicated in a case of sexual harassment in his previous company. So when that was discovered, his services were terminated. So, I mean, if you look at it from that point of view, if you have very clearly laid out code of conduct of breach of confidentiality, which I think in a lot of companies now, people have at least on let's say non-disclosure NDAs that they sign, but I don't think they word it very well. So that could be done. On the other hand, I have also seen cases where the external member is misleading the client. Okay, I've actually had a case where, and this happened last year, where we were being marked copies in the local committee because the external member was writing directly to the complainant that you don't need to worry, I will handle your case and I will be, investigating into your complaint. So it was a case actually meant for local committee. But the external member was committing two major errors. One, she was not explaining the jurisdiction. And by the way, this lady was a lawyer. She was not explaining the jurisdiction of this case to the complainant, that it's actually a complaint for, the local committee. Second, she was also breaking the law of the quorum, because you need a quorum of 3, and the presiding officer can never be the external member unless, there are some very, very extraneous circumstances. So in this case, as LC, we couldn't do much. So we actually then wrote to the district officer that you really need to pick this up. So where the external member is violating, and if I get to know, for example, as part of LC, I have done that.
That's quite an insight. Now comes the main question, and I think Sumit will start with you because I want both of you to respond to this. What is the cost of non-compliance? What, according to you, is the cost of non-compliance? Of course, there's some mention of it in law, but we want to hear both from legal aspect and if there are any soft implication of non-compliance.
So I'll probably cover the soft implications. I know there are definitely a lot of legal aspects towards it, which I'm sure Jyoti will have more details around covering that. But from a software aspect, to me, it's all about reputation of an organization. It's all about will people even want to join an organization that is non-compliant to some of these things. So one simple example is we are required to provide safe travel back to women after let's say 8:30 p.m. in the night. Now let's assume my office timing ends at 8 o'clock and I say I will not provide any cab because legally I'm not compliant. I'm compliant, right? My shift is ending at 8, but because my shift is ending at 8, I know if I'm based out of Gurgaon and I have a female drop that lives in Noida, it takes a couple of hours for her to go to Noida after 8. Am I legally compliant in not providing transport? Yes. But is there a software aspect which I'm missing? Absolutely yes, right? I'm probably not considering the safety security of that female. And if anything happens in that context, I will not be legally held responsible, but then my reputation goes down. I will not have female employees joining with us. Similarly, if let's say if I'm less than 10 employees, I again don't have any legal compliance, but any case happens, then why I'm not recommending my senior people or even male employees to go through training, understand PoSH, even if it's not required. It's all about having that compassion about this overall, right? It's, and like I always say, women safety is not for women to worry about, it's for men to worry about, and that's where we need to teach that a little bit better for our world to be better.
So basically what you're trying to say is loss of credibility, loss of trust. These are two aspects that is important. Non-compliance, these are bigger prices that, while whatever penalties are laid down by the law, but
Absolutely.
these are bigger penalties that an organization will pay. And considering it is a supplier's market right now, you have to ensure not only that, but I think as in most ethical organization that you want to become, and the social responsibility that you have as an organization, I think these are some aspects which is much bigger and larger for any organization.
Absolutely, and not just for employees, the vendors we work with, right? Why do we even think of only employees as it? I'm not legally compliant again on some of those aspects, but even if I'm working with vendors, there are female leaders in the organization who work with different vendors. Why don't I look at them as well as a part of the whole ecosystem? So those are softer aspects we all need to think through.
That is very interesting, because currently I got one case where it is between the two vendors, and as a principal employer, we are figuring out how we can help and support. So we are kind of creating them, giving them a bit ecosystem. We are creating an ecosystem for them where they can help resolve it within that organization. If not, we've given them a platform that they can use our IC platform too. So this is nowhere written in the law. This is not, they can straight away say that that is 10 or more employees. I have nothing to do with it. But this organization clearly says that no, we will help you. We will ensure that, because having cases is okay, but not treating those cases, I think, is something that is just not okay. So thank you for that bit. And Jyoti, now I'm coming to you from penalties laid down in the law.
Sure. So just to kind of put a figure to what Sumit said, I don't know if you guys remember this case. It was a High Court, Madras High Court judgment, 2014, I think, ISG Novasoft. Talking about just reputation, there's also a huge financial penalty, when you violate the law. Either you don't follow the principles of natural justice, or you don't form whatever. So in this case, the complainant got 1.68 crores the company had to shell out. So that's the level, apart from the reputation. Of course, I still, and I know I'm quoting Uber over and over again, but Uber is such an example, because I think a couple of months ago, there was a HBR article which I had read, where it talked about how Uber had such a breach of trust and credibility that it had to practically rebuild itself. And they went through a whole, authenticity exercise to build that, because there were just so many cobwebs that came out. So those, I thought I'd quote those two examples. Coming to the violation under the PoSH Act. Now, I don't necessarily agree with everything, but I'll share what the Act says. So the violation is only on 3 counts. One is if you don't form the IC, and we have enough judgments where, the employer has been slapped. Even we in LC have slapped a penalty of 50,000 rupees on employer if the IC has not been formed. Okay, so not constituting an IC is a violation. Not following up on the recommendations of the IC is also a violation. And also not, handling cases appropriately, inquiring into and recommending on, malicious cases is also a violation. Now, when you go back to, for example, the slides that you had shown where you talked about the role of the employer, I have not yet come across, in the Act, it's not mentioned, and I have not yet come across any judgment where an employer has been penalized for not, for example, running training programs, or for appointing an IC which is, not trained. There have been cases where IC has, where the courts have asked the ICs to be reconstituted. But, there's been no penalty, so to speak. And I think that's, to my mind, a little bit of a lacuna. Hopefully we'll do something about it, because somewhere the spirit of the act was to make it, to make cases of sexual harassment easier to redress, so that every case doesn't reach the court. But unfortunately, I think that's where we are a little lacking. So these are the three sort of main, I would say, provisions. Now, if it's a first time offense, yes, there's a 50,000 rupees fine. If it's a second offense, then this can go up to 1 lakh. The act also provides for cancellation of business license. But again, I have not come across any case law where this has happened. And even, I was going through some reports by some esteemed lawyers where they are even questioning what is it, when the act is saying cancellation of business license, what do they really mean? So, I'm as, I would say, clueless as everybody else there. There is also a provision, and this is something, Smita, that you had spoken about, and I think it's important to bring it up here. There is also a provision under the Companies Act, which was through an amendment in 2018 under section 134, that there has to be a disclosure in the annual report. Now, that disclosure, again, unfortunately, is only to do with the constitution of the IC. So it's not a disclosure, that trainings have happened or not, or whatever. So it's a very limited sort of a provision. And the violation of that, I think there is a lot of stuff which is doing the rounds on the net, which is being misunderstood. People are wondering whether they will be imprisoned if there is a violation there, or will they be like a 25 lakh fine. Actually, all that's was also brought about because I think this was a provision maybe at some point in time, but there has been an amendment in 2020. And that amendment is fairly clear. I don't have a copy of me. I don't have a copy of it handy with me, but the 2020 amendment to the company law, specifically with reference to section 134, has no provision. The entire, imprisonment thing is omitted. Okay, so I just want to sort of clarify that. And the other thing is that even the penalty on the directors, because see, the annual report also, you need a minimum of 2 directors. So whoever signed the director's report, where God forbid, this disclosure is not there, the penalty on him or her will be 50,000, and the penalty on the company will be 3 lakhs. So I think it's important that as we speak, there are amendments being rolled out, which we should be aware of. And I think somewhere Google or the net needs to remove the old stuff, because that creates a lot of misinterpretation. Yeah. So
it does create a lot of confusion, and that needs definitely clean up. While I'm going to go a little back and forth, I think when Sumit was answering a question, Sumit, somebody was asking who is supposed to be a designated employer. While I casually said, Sumit, you're the HR head, so you are the employer. So is that the right definition of employer? Who can be designated as an employer?
No, so we'll have to define that, right? It need not be the HR head. It could be it could be any other lead that we identify. So I am currently designated partner and head of HR. Previously, there was another gentleman who was designated partner, and I was the head of HR, and I was also part of the IC. But even if I'm not part of IC, doesn't necessarily mean that as a head of HR I have to be external. I will have to be the employer designated. So it has to be defined also in the policy very clearly as who's taking the final call when the IC recommends. So it can be anybody else, anybody at a senior position that we nominate.
Okay, so you think, and Jyoti, maybe you can add to it. Do you think that part should be defined in any policy, saying that this person or should be named saying that this person is the employer, and what do you think about that?
I think from my perspective, it helps, but I'm not sure if it's required as a legal. But I think it helps because that makes it clear as in who takes that call finally. Otherwise, it could lead to some ambiguity.
So, I mean, for me, I go by again what's defined as the employer in the Act. Now, the definition of employer in the Act is actually very, very broad. And before we come to the concept of employer in the context of compliance, I think the bigger one that I struggle with is, in the LC, because the LC is supposed to handle cases which are against the employer. And more often than not, the employer is not one person. Unlike, for example, the Factories Act, where the occupier is very clearly defined. So here it's a little iffy because here the heads of, and there's always this back and forth on, so is this the jurisdiction of the LC? Because, I mean, let's say, the cases against the HR head or the finance head or the CEO of a company or not. So I would say there is only one case, the Jaya Kotade case, which talks about the definition of employer, and that is more in the context of I think a university and stuff like that. But other than that, this definition per se, or whether there is one single person who is the employer, has not been addressed, at least with respect to this act in the courts. So therefore, I'm going purely by precedence, and I'm saying that when it comes to the IC's recommendations, for all practical purposes, the MD or the CEO of the company is the employer, and then he delegates the authority of implementation to maybe the HR head or whoever else. So typically it will be the CEO from the point of compliance, delegating authority to the HR and admin head. But from the point of jurisdiction, like I said, it's a much wider field. Yeah.
All right. Thank you for that. There's a question. I don't know if it's a question, it's a response. Compliance, employer to be conscious on schedule of the inquiry. 2, employer to comply the recommendation. I think Sundarajan is sharing this. There's a penalty on the employer for this non-compliance. Also, liabilities also on the respondent to pay the liquidated damages as per section 15. So I think he's adding to what I was sharing. Thank you, Sundarajan, for that. He also says something like tracking compliance analytical report of the annual return submitted by the employees or by the government, though they make noise as and when something happens. Views, please to know, is there any good state doing this sincerely? I think Gurugram is doing something amazing. I'm really fond of the way they are. I don't know about tracking, at least collecting data. They have a very detailed form, which I have not seen any state having it. Now, how well they are maintaining it is a great question. Yeah.
So let me let you in a secret here. Until recently, they were accepting, I think till about a year or 2 years ago, they were actually accepting physical submissions or submissions by post. And in the LC office that we have, there is this huge trunk. It's a huge trunk where all these forms are lying. And I was talking to the district officer the other day. So so I think the initial years, it was more about, okay, let's just get them to comply. Let's get them to, send in. Now, in the last 2 years, most of this is electronic. So I can assure you that at least the Gurgaon district is going to be looking at not just tracking, but also using this for research purposes, where we are probably going to come up with, like one does have a base idea of how many, registered companies there are. So some ratio of how many have complied versus not complied. Then, how many overall in the year, how many cases have been reported. So that kind of research is what is planned. Now, whether it will actually happen, we don't know.
At least the mind is in the right place.
Yes.
Which is important. So, but you want to share any case laws around non-compliance, which you think is important for this group to know? Or anything that you want to highlight?
I think from as simple as ensuring that you are providing the end of the year report, like for example, right? It's as simple as that. Why is it important? Because at least that keeps things in check, and you're ensuring that if there is a case that has happened, then you are proactively keeping track of it. You're informing. You're making sure the paper trail has been correct. There has been the right justice that we are looking at. So as simple as that is it's a once in a year activity, but for doing that you need to ensure that throughout the year you're taking effort in not just maintaining but ensuring that the records are correct. So I think that's one simple law, but it's so important because it helps in ensuring that you're recording your things to the government.
All right. Jyoti, any case law, anything that you want to speak about in this particular space?
So more about, more than case law, because most of the case laws, honestly, on non-compliance are largely around not forming the IC. So, I mean, I've already spoken about that. And also, there are a lot of case laws around violation. So it's non-compliance of the procedure. So violation of natural justice. Now, in most of those cases, I don't want to sort of bore you guys with the details of each case, but in most of those cases, wherever there's been a violation, like for example, I think there was this case where the respondent had said that he did not get an opportunity to cross-examine. Another one case was where he said that the evidence was not taken into consideration, and so on. So from those case laws, what has emerged is that, for example, when it comes to evidence, we don't have to be strictly abiding by the law of evidence. When you're looking at a case, when it comes to cross-examination, yes, it's a clear violation. So then the case went back for being re-inquired, and then there was this case and a series of cases on what you call as the Wednesbury principle, which is around that the award that you're recommending is in tune with the nature of the offense. Now here there are cases, high court judgments, which have set aside because the the award may have been too harsh or too I would say lenient. There are also cases where we've had a situation where, for example, IC has recommended that the person be, let's say, given a warning, or maybe he be transferred, but the employer has decided that that is too lenient a recommendation and has decided to make it harsh, maybe a termination, and then the respondent has gone to court to appeal against that. So in all of these cases, and that's why I said there is just so many of such cases, that in all of these cases, I think the learning is that any kind of violation of the process is looked at, by the High Court or the courts. And that's when, for example, the ICs need to be very well aware, and they need to be very mindful that you need to actually capture everything. That's why the IC training becomes important. So nowhere, like nowadays, even when it comes to, for example, I've just got a case, we've done the first examination, we will send a formal mail that, okay, please let us know, like in the meeting you agreed that you do not want conciliation. We just needed you to confirm that. So the person will confirm. So I know that I have taken care of the conciliation aspect, which is my first part when I get a complaint. Similarly, let's say I've done the examinations. Now, when it comes to witness statements, now this recent case that I'm handling, 2 witnesses were proposed by the respondent. We met both the witnesses. After the meeting, the transcript of the hearing was shared with both the witnesses for them to confirm. Now, one has confirmed, the other, there is just no response. Now, the question is, because I can't, as IC or LC, can't, share, because I have to also share witness statements with the other party. So I cannot share unless I have a written confirmation from the witness. So in this case, the second witness, since he is not confirmed, I am now not going to even have it in my overall order that I pass. So now these are very minute things which we need to really take care of. Similarly, let's say I had a case where we did an ex parte judgment on a respondent, and this guy went to court that I was not given an opportunity. Now, in this case, here it's very important that there are 3 consecutive hearing notices to be set. If he doesn't appear, then, a notice with a 15 days gap for ex parte to be set. Now, what I see in a lot of ICs is that they forget. They assume that it's 3 in total. It's actually 3 plus 1. So these are small things that we have to be very careful about. And but no case law is actually inquiring. So they do not reappreciate evidence and they do not inquire into the case. But what they do is to send it back, or they set the order aside. Another thing which I've seen happen, it's happened a lot in local committees. I don't think IC would be subjected to that. There will be a long drawn case. Everything, would take enormous amounts of time to do. The judgment will be passed in favor of the complainant. The matter will still go to court because, unlike the respondent, who happens to be a woman who's already been maybe terminated or whatever, the complainant has deep pockets. Maybe he's a promoter, because in our case, we deal with these kind of cases. They will go to court and then they will do an out of court settlement. Now, this is something we don't have a handle on. And it's happened, and it's very heartbreaking because, like in this particular case, we had recommended that the director, and this was against the director, we had also recommended, that to the ROC. Of course, the ROC is not bound by our recommendation, but in this case, this was a serious case. So we had also recommended disqualification of the director. So he actually went to court, and then they did an out of court settlement. So, the entire 6 months went down the drain. I mean, there's so many cases like that.
I know we can go on.
Yes.
And there are few questions coming. Can you apply the comments of this over to Supreme Court case a few years ago of the former CJI? Could that case be considered as appropriately handled?
Absolutely not. I mean, what do you want me to say? And I think it's very sad. If you look at the recent things also, okay, now at least in the judiciary, they are looking to set up committees and all that. But the recent one where they are not expecting political, because a lot of harassment happens in political parties as well. But I mean, honestly, the spirit of the act is really very good. I think the way the act is substantive, procedural, also building in a lot of sensitivity. But in actuality, I can tell you for a fact, I obviously can't speak for other local committees, especially, when we deal with cases against founders and promoters. All of them go to court. All of them. I actually had a case where we had 3 cases from the same multinational. And every time we called the respondent, who was a senior person in that multinational, he would come with his legal team and we would tell him that the legal team needs to be out. And then they would go and get a stay against us. So sometimes I feel that we are wasting so much energy and resources. What I've started doing now, therefore, and it's a tough ask, honestly. Earlier, it was my chairperson that I had to manage. Now it's my local team that I manage, because everybody just wants to make everything very legal. So I have now just decided that to the extent possible, let me, just spend time with both the respondent and complainant, tell them the benefits of conciliation. So it's worked in, I think, 2 cases in the last 6 months, where one case was a case of drunk dialing, where the guy was completely not willing to. So I've somehow I think this is where my psychology background comes in handy. I somehow convinced the guy. I said, "You want to take it to lens? Then it's not never ending." So he admitted his drug dialing violation. She is okay, and we've managed to conciliate. The other case was where again this was a startup, and the complainant had already made up her mind that she's going to leave. So it was more a question of that he should not do this with anybody else, so that, and this guy was going through a Series A funding. And, especially with startups, this is a big one. You get embroiled in a case of sexual harassment, your entire thing, but they still need to be told that what they did was wrong. That whole difference between retributive justice and restorative justice. So I think in a lot of LCs as well as in a lot of ICs, the immediate thing is, how could he do that? And retribution is the thing that comes first. But restoration is what I think really helps if you really want to go by the spirit of the act. I know I'm talking too much, so please stop me when I'm...
No problem. It's very rarely to get you. And if you're speaking, you're only sharing knowledge. It's great. I think there's a question for you on that on first BEAR Act, read PoSH seems ineffective and ambiguous. What's your take on that?
No, like I said, I think the act is pretty, I would say it's pretty fulfilling. If you look at some of the other acts, they are not as fulfilling, but unfortunately, the spirit of the act is what I don't think is being understood by people. Like, forget the respondents being what they are. I think increasingly complainants are also becoming more frivolous. Like at the drop of a hat, they will file a complaint. A lot of sexism and gender discrimination or workplace bullying reporting is also coming into the act. And I can understand why the ICs also wonder that, why should we do this? So I wish the spirit of the act was understood and the genuine cases were handled. Personally, I find that conciliation, the option which is there in the act, is a very good provision. But even though the act very clearly says that no party should really take on, legal recourse, I think the complainants are also now going very, very legal.
Yeah.
So that's making it.
Yeah, I have a witness coming in with his lawyers.
Oh, just imagine. So that's a problem. But I think having said that, like I said, I'm now seeing some success on conciliation, and I'm hoping that, that like I had a case where the drug dialing case, the demand. So this was the complaint was actually drafted by the lawyer, and he had demanded 25 lakhs as compensation. And eventually, it was a series of discussions and all, where it was very clear that the lady just wanted to make sure that this act is not repeated. So, yeah.
So I think we have come to the end of the discussion. I think we have covered the cost of non-compliance. Okay. And being compliant, I think, is just a starting point. As an organization, we have to not just do checking the box, but go to a level where we create an absolutely safe and thriving workplaces. Okay. Actually, in the morning when I was discussing with a woman, and as you said, that sexism, is so much in some organizations. It creates such a toxic culture that women drop out of workplaces, and it has been happening continuously. So I hope we are able to create this system, this IC more stronger, so they can address to such cases too. Unfortunately, currently we are looking only at sexual harassment cases, but I hope this team and a jurisdiction can increase and take up the toxic work culture and create safe, happy workplaces. So Sumit, any closing comments from your side?
Yeah, I think just to ensure what you said is understood. It's not just the law that we need to look at, right? It's the spirit of it. It's looking at, being aware of it, just ensuring that there is a safe and secure environment around it, And like Jyoti was also mentioning, right, it's on both sides of the thing. The female as well as male taking it in the right spirit of using this law. They, of course, it's a law that has been in place for a while, but it has got its own set of ambiguities that needs to be further clarified and confirmed. So we should all look at compliances on various aspects, not just legality of it, but softer aspects also.
Okay, thank you very much for that, Sumit. Jyoti, any closing comments from you? You're on mute. You're on mute.
Yeah, I think I've spoken a lot already. Okay.
Thank you very much, both of you. I think I had an amazing conversation because it also gives me many ideas because as I think somebody mentioned that law is not exhaustive. The 2013 Bear Act is not exhaustive. And what really makes it exhaustive and usable or practical are these conversations, which gives us ideas, thought processes, which maybe we are not thinking, but experts like you all are thinking. Okay, thank you very much. And I think we had a lovely audience and loads of questions from them. So I will conclude. I think, Jyoti, you have anything?
I was just going through the chat box. So I think somebody wants a compilation of the case laws. I'll be happy to do that and share it with you. So just give me some time. I just thought I'll respond to that.
Yes, please. Yes.
All right. Okay.
Thank you very much, all of you. Thank you. I'll be stopping the recording and the live stream.